Thank you for tuning in to another episode of Retire Right. I am Ryan Wyatt. Today I'm joined by Ron Wyatt, a fellow wealth advisor here at the firm, and a guest, Andy Sykes with Sykes Elder Law here in Pittsburgh, Pennsylvania. Andy, how you doing today?
Good, Ryan. How you doing?
Good. We appreciate you joining.
My pleasure.
Today what we're going to do is we're going to talk about estate planning and asset protection as it pertains to estate planning. So we'll cover some unique strategies that Andy and his team are using with their clients, and ultimately some strategies that we actually are talking to our clients about. So we figured it would be really good to bring Andy in today, and we certainly appreciate you joining.
It's my pleasure. I'm a fan. I enjoy your podcast, so It's nice to be a guest.
Yeah, thank you. Andy, I know I gave kind of an overview of what the topic is, but I wouldn't say that's a formal introduction. So do you mind introducing yourself and maybe shedding a little bit more light on what it is that you do with your clients?
Sure. I'm a certified elder law attorney, and I practice elder law in Mount Lebanon, and we also have a satellite office in Philadelphia. And so we practice in three main areas: Medicaid planning, estate planning, and estate administration. And those are kind of areas that sort of cross-pollinate each other a bit. So our expertise in one area helps us to be better in other areas.
There seems to be a lot of confusion about Medicaid planning. Is that what you find out?
That was my introduction into elder law. Actually, before this, I was doing litigation. And there's not a lot of understanding about what it is that you can actually do in terms of Medicaid planning.
Okay.
A lot of times people think if you're in the nursing home, it's too late to do anything. There's actually a lot that we can do using different techniques that are permitted under the Medicaid regulations to help protect assets.
Awesome. Well, I think we're going to get into that. What I was hoping that we could do is, I always say this, we start high level and then we kind of drill into the details as we get, later into the episode. We have a couple questions that we've actually been sitting on for a while, waiting for the opportunity to ask them. So I think that this is a really good time to do that. So Andy, I have a couple just high-level estate planning questions before we jump into the asset protection. So the first one is, when it comes to estate planning, is a will enough?
In some cases, yes. Sometimes people just need a will. You usually need power of attorney and healthcare directives too.
Okay.
Because when you're doing estate planning, really what you're doing is you're planning for the possibility of incapacity and the possibility of dying.
Okay.
Right. So you definitely, I think, want to have power of attorney and healthcare directives in case you become incapacitated during your lifetime, but need somebody to make financial decisions for you, make healthcare decisions for you. And then a will in case you die and you want to make sure everything goes the way you want it to go.
Okay.
And then is it enough? Not for everybody. Sometimes we might need some sort of different trust structure during somebody's lifetime, or even for their heirs.
So that's actually a perfect segue into the next question that I had, which is, from a general standpoint, when do trusts, getting away from the will, the power of attorney, the healthcare directive, when does a trust start to become a suitable tool to use?
Yeah, so it depends on what the purpose is. So when we're meeting with clients, we look for different things that would indicate that there might be a need for some sort of trust structure that would be beneficial to the client. For example, if the client has real estate in different states, or they really value privacy, they want, they have bequests going to minors, and they want to make sure this is private. These are the kind of things that I would hear, and I'd think this person might want to have a living trust, a revocable living trust, so that they avoid probate.
So can you explain the real estate in different states? Because there's some confusion on that.
Yeah, so if somebody had, maybe they have a place here in Pennsylvania and then they're snowbirds, so they have a place in Florida too. If their executor lives in Georgia and they have a probate estate here in Pennsylvania, and then the executor would also have to open an ancillary one in Florida. That would be a lot of work, for somebody from out of town to come into Pittsburgh, get sworn in as the executor, and then open another one in Florida. we're talking about a lot of expense and everything.
So real estate's probated by where it's located.
Right.
Okay.
Yeah. So if you own it in your own name and just are directing things with a will, that can be cumbersome for your executor. But if we create a revocable living trust and then retitle those pieces of real estate into the name of the trust, then the executor in Georgia, that might be the oldest son or daughter, can be the successor trustee, so that when the owner passes away, they can just take over as the trustee and then work with a realtor to sell the property, and it's going to be a lot simpler.
Okay. Is it safe to say that estate planning in some capacity is really necessary for everybody?
I think so. If you don't have it, the state has a backup plan for you. Right. So if you don't have a power of attorney, there's a process by which a judge can appoint somebody to be your guardian.
Okay.
But you might have seen like Britney Spears, examples like that, and just from our clients' experiences, it's cumbersome, it's expensive to have a guardian. It takes time. It might take 30 to 60 days to get a guardian appointed. It's much better to have your own plan. Pick your own person that's going to act for you and have it effective immediately. So if something happens to you, they can start using it right away.
About it, right?
Exactly.
So is it safe to say, so on the most basic end of estate planning, that might look like making sure that beneficiary designations are set up so that you're avoiding probate. On a more complex end, we'll get into some of the asset protection stuff, but you might have some asset protection strategies in use or trusts, and that's really meant that can give you control while you're living and control after life to ensure that the assets are passed the way that you want. So that would be kind of like the two ends of the spectrum there.
Right, that's a good point. And the way I like to think of it is it's good to have a comprehensive plan so that all of the parts of it, whether it's like a beneficiary designation with your life insurance or retirement accounts, lines up with your overall plan for how everything's going to go to your beneficiaries. So you want to make sure you have, your power of attorney, your beneficiary designation set up the right way. Think about, if I passed away, would there be liquidity to pay for the inheritance taxes?
Mm-hmm.
Things like that, so we can pull it all together in one comprehensive plan.
Gotcha. Okay. I appreciate the overview of some of the general aspects of estate planning. If you don't mind, could you describe or define what your view on asset protection is?
Sure. I think of it in a couple of different ways. One is during your lifetime.
Okay.
Do you need to protect assets during your lifetime for some reason? Not everybody does, but for some people this is very effective. And that goes back to my entry into this field being Medicaid planning. I became very aware of all the different ways that people can lose assets during their lifetimes by having to spend down for a long time on nursing home care at, currently about $12,000 a month.
Yeah.
So when I started doing estate planning, I kind of took that awareness into that and tried to come up with ways where we avoid any type of nursing home crisis and plan ahead of time for maybe using a trust to protect assets so that somebody wouldn't have to spend down so much to qualify for benefits if they were in that situation. So that's the first part, is the lifetime asset protection. And then I also think of it in terms of once you're gone and you're leaving things to your heirs, what can we do to protect assets for your heirs?
Gotcha. So focusing more on that, the lifetime protection, we see this often. No, I shouldn't say often, but we certainly see this, and there's some cases that we've had to work through with having these exact conversations with clients. The thing that I'm curious about is, at what point in time, because nobody knows what the future holds, but at what point in time does planning for a potential healthcare need down the line when you're healthy today become relevant? Like, how do you know that those are conversations that you should be having?
Yeah, so I kind of started having these conversations with my clients that are going into their retirement years, and we look at the way that their assets are arranged, and from the standpoint of particularly long-term care. Could somebody pay for long-term care from their income and their assets the way they're currently arranged. And if they could, then we don't have as much need to do lifetime asset protection planning. But if it turns out that if, paying $12,000 a month would be a big burden and take a lot out of their savings that they would be relying on or that their spouse might be relying on, maybe we need to have a conversation about what are some steps that we can take so that if that happened, if somebody needed to pay for like nursing home care, that we could have more left over for your kids.
Okay, that makes sense. Ron, did you want to?
Yeah, I'm just real curious about like the pros and cons of proactively planning with like different types of long-term care policies, hybrid and regular policies, compared to there's a 5-year look back, so it gets real confusing, and then, getting an irrevocable trust involved too. And so if you can kind of go over some of those, I know that's a lot, there's 3 different things.
Yeah, there are different approaches. There's, more than one way to skin a cat, right? So I like the long-term care options that I've seen in the market currently. When I first started out doing this 25 years ago, it was more common for people to have long-term care policies that were just pure long-term care insurance. Mm-hmm. And then I see less of it these days as the premiums have gone up.
They've skyrocketed.
People have edged away from that. Right. But there are a lot of good options out there. Those hybrid policies where people might buy an insurance policy with a long-term care rider. And that way, if they needed long-term care, there might be, a multiplier of 3 or 4 times what they paid for that that life insurance policy to pay for long-term care. I think that's a great approach.
Right.
Yeah. We often in our plans we put in the potential cost of long-term care to see if people can cover it. But I've never written a traditional long-term care policy, but I have done some of the hybrids because they make a lot of sense. You get, like you said, a multiplying effect. If you need it, if you don't need it, you get a death benefit. So it seems to be a pretty sensible way of doing things.
Yeah, so I look at that. Have people done that, or is it something that they could do? Mm-hmm. So that's one approach, and I would talk to clients about the advantages of doing something like that. And then I look at whether if they haven't done something like that, do they have things that are obviously exposed to being spent down?
Okay. So what do you do? Say that a person doesn't have long-term care policy, and we can go over an individual compared to a couple. But let's just say that when one person goes into a nursing home. Can you explain the planning that's done for a couple if one person goes in compared to an individual?
Right. So you look at their countable assets versus their assets that are deemed exempt under the Medicaid regulations. So in the case of a married couple, if the well spouse is living at home, maybe they have a house that they own together, and it's called the community spouse. They're still in the community. So if the community spouse is living in the house, that house is going to be exempt.
Okay.
If the community spouse has retirement plans, IRA, 401k, something like that, those will be exempt. Not in every state, but in Pennsylvania. So this is a big advantage that Pennsylvania residents have. But they might have other things that are countable, savings, checking, brokerage account.
So a lot of joint assets, for example, would be counted.
Yeah, so whether it belongs to either spouse or both
Okay.
together, what we look at is what would be countable,
Okay.
right? And then from the things that are countable, the community spouse is entitled to what's called a resource allowance, a community spouse resource allowance. And that's half of the countable assets, but it maxes out currently at around $160,000. So we figure out, what is the amount by which they're over what's allowed by Medicaid to have Medicaid start paying for the monthly cost of care. And with that amount that they're over-resourced, we work with different strategies to see if we can spend that down in a way to allow them to qualify for benefits now, but is favorable to the community spouse.
So what you're trying to do is cover the long-term care cost, but save as much assets as possible for the community spouse.
Yeah, if they're in that category where they could qualify for Medicaid benefits, it might be a case of taking $100,000 or $200,000, for example, and putting that into a certain type of Medicaid qualified immediate annuity that would pay income to the community spouse, but take this amount of money that's preventing them from qualifying for benefits now, turn that into income, and now Medicaid is paying for the institutionalized spouse's care.
So they're mainly looking at assets, not income?
They're looking, primarily at assets.
Okay.
Schedule your complimentary review with Ryan and his team today. Just visit them online at wyzewealthadvisors.com or call 724-271-7019 to get started. That's 724-271-7019 to get started.
And just to back up for 1 second, really what we're talking about right now, I know we covered it briefly at the beginning, but we're getting a little bit technical on this, so I want to make sure that I just revisit what we're focusing on here. And this is going to be a strategy that most people would use if they run a comprehensive plan, to Andy's point, and they're not necessarily in the camp where they could comfortably fully fund some sort of healthcare need at the end of their plan. For example, long-term care. So these are strategies that would be used to protect assets, allowing you to, in an ideal world, qualify for Medicaid. That way, if you did need support, you still have assets left over that you could use to make sure that your lifestyle in a facility is the best that it could be, but you're also getting support from a Medicaid standpoint, and that's what is being used to fund your stay inside a facility. Was that a fair summary of the strategies that we're talking about and kind of the use case here? Yeah,
and maybe it'd be helpful to have maybe a couple of examples. So I just talked about one where you might have a married couple that ends up being $200,000 over-resourced. If we find somebody that might be in that situation 10 years from now, we can plan proactively, and maybe then we would think about creating a trust, an asset protection trust, to put their house and some of their countable assets into, so that if they do end up in that situation, instead of spending down $200,000, maybe they're spending down $40,000.
Now, in order to do that, the trust would need to be set up in a specific way, which is essentially taking away their control over those assets. Is that correct? Because it becomes an irrevocable trust.
Right. To work for Medicaid spend down purposes, it would have to be an irrevocable trust.
Okay.
So I'm kind of curious, like if you put money in an irrevocable trust, what is your access to the money, like for income? A lot of people, if they put money in the trust, they still might need income from it.
Yeah. So one common way to do that is to use what's called a grantor type trust. Mm-hmm. We set it up where the principal is for the beneficiaries, but the settlors of the trust, the people that create the trust, are entitled to income. So that gives them that advantage that they're getting income from it. And it also has other tax advantages too, like preserving your step up in basis for capital gains tax purposes, or if you sell your house, you get a break on your capital gains. If you've got the house into a grantor trust, even an irrevocable grantor trust, you would still get your capital gains tax exclusion.
What do you see people struggle with when it comes to the irrevocable trust? I think that at times what I've seen is that people get nervous when they associate the lack of control with the irrevocable trust. So, if you're using these strategies for the benefit of qualifying for Medicaid and protecting assets, but you're giving up some control to do that, what is the benefit for giving up that control, I guess?
Sure. Yeah, that's a really good question. And it sounds scary, irrevocable. Right. It sounds so permanent.
Right.
So a few things that we can do to kind of address that concern. So one is, it's common for me to name the settlors of the trust as the trustee or trustees of the trust. So now they feel like they have control because they can determine if they've got their investments in the trust, they can still determine how it's invested, and they can work with their financial advisor to determine, how we're going to set this up financially. So that's one way. Another way is to have the ability to change beneficiaries if you want to, so now you still have some more control over it. The ability to make distributions during your lifetime to a beneficiary. Okay, so if we still want to give money to one of our children, we can do that. And then another thing about Pennsylvania law is that even with an irrevocable trust, you can still modify it or even terminate it if you have the consent of all of the beneficiaries. Okay. So if all the settlors and all the beneficiaries agree, you could even just terminate the trust and do away with it. So that's a conversation we have with our clients is, the beneficiaries you're thinking of naming, what's your relationship with them like?
So I guess what I'm curious about is, you mentioned income, but can you explain that in a little bit more detail? Because I think that's a lot of, if people hesitate about an irrevocable trust, that's what I often hear.
Yeah, so somebody might have an annuity that's generating income for them. So we want to make sure that we get it set up so that they can still get income from that annuity while at the same time having it in an irrevocable trust. So we want to make sure we work with the company that has the annuity, make sure they're okay with it. Mm-hmm. So that's an example.
So can I say that I have the irrevocable trust? Can I just take income as I want, or is it based on the HEMS, health, education, maintenance, support? How flexible is it?
Yeah, so if you set it up so that it generates income,
okay.
There's, not to get too technical, but there's this thing called the Principal and Income Act that determines what is principal and what is income.
Sure. Okay.
Usually it's pretty straightforward, interest, dividends, annuity payments, things like that. But the way I explain it to clients is in terms of the income that's generated.
Okay.
In a grantor type trust, you're taxed on all of the income.
Okay.
So I think you have three choices then. You could take all of the income out and pay the taxes and keep the rest in your checking account. Sure. You could just take out enough to pay the taxes and leave the rest in the trust if you want to grow the trust.
Right.
Or you could leave all the income in the trust and pay the taxes from some other source if you really want to grow the trust. So I think if you have those three choices, you can come up with an approach that suits the individual.
So just one more question related to that, Ryan. So I can take all the income out. Okay. So how about if I need more income for buying a car, has some unexpected expense? What can happen there?
Yeah. So one of the conversations we have when we're setting this up is to actually put on a spreadsheet all of your assets and put in the two columns what's going to go in the trust, what's going to be outside the trust, so that I'm comfortable with my amount of income that I have from other sources, what I might get from the trust, what I might take out of my retirement account, which we typically don't put into a trust.
Sure.
So that's a conversation on the front end. Are you comfortable with what we're leaving outside the trust, where you might want to buy a car or something like that? There are occasions when somebody might, really want some principal out of the trust and make a distribution to one of their beneficiaries.
Sure.
And then, it becomes the property of the beneficiary. They could do whatever they want with it, like buy mom and dad a car. So you have to have a certain level of trust and cooperation with your beneficiaries. Right. And you have to be sure to honor the formalities of the trust. It can't go from the trust to the settlor, but it can go to a beneficiary.
Got it.
I wanted to ask a specific question, which is around, I've seen this not too long ago with a client. You have a lot of qualified assets. You want to start, and when I say qualified assets, just think like a traditional IRA. Maybe money was in a 401k before, you retired, you moved it to an IRA. That's money where if you pull that out, it's going to be taxed as income. But that kind of feeds into the strategies that we're talking about. If you want to move money into this irrevocable trust so that you're making the smart decisions for Medicaid planning and asset protection, part of that is moving accounts into a trust, which would be a taxable event. So are you having any discussions with your clients that might have larger balances in these qualified account types?
Yeah, that's a really good question. So you're right, you would have to give up something to take something out of a traditional account and put it into a trust. And there are situations where that might make sense.
Right.
But you have to understand that you will be giving something up. You will be taking that tax hit on the front end. Maybe that's worth it for the asset protection long term, and some clients do come up with that.
Right.
And so a lot of the discussion we have comes back to, if you needed to pay for care, how could you do that? Is there enough? Do you have enough in investable assets at maybe? I hear from the financial people like 4% is kind of a sustainable
rate,
something like that
4 or
you can
5,
sustain that for a long time. Looking at 4% of your investable assets plus your other income, could you pay for the cost of long-term care? And if you could, then there's not as much need to have an asset protection trust during your lifetime. But not everybody is in that situation.
Right,
so then we think about, okay, if we put things into an asset protection trust, what can we put in that you'd be comfortable having in there, and how would that affect things like future growth on your
Right.
retirement account? Because tax deferred growth is a great thing, and I think clients should fight to have that.
Yeah.
So it seems like people who do not have a lot of wealth probably can't afford some, or it probably doesn't make sense for some of these planning techniques, but people that are really high net worth can fund it out of pocket. So it's really the people in between.
That's
Is that
true.
a fair statement?
Yes.
Okay.
Right.
And one thing I was real curious about, so you used an example of a couple. I wouldn't mind also if you could use an example as an individual. And then there's a lot of confusion about the 5-year look back. If you can somehow also explain that as it relates to the examples, that'd be great.
Yeah, sure. So the 5-year look back is when you file a Medicaid application, there's a question on there that asks, have you given assets away or transferred them to a trust in the last 5 years? And if so, there may be a penalty associated with that. You might be ineligible for a certain period of time. So, we think about that when we're doing the crisis Medicaid planning. But, when you have somebody, maybe like a single individual, if we know how those rules work, we can use them to our advantage.
Okay.
So maybe you've got a single individual just going into a nursing home, and we might want to make a gift intentionally, knowing that there's going to be let's say a 10-month period of ineligibility because of that gift. And then if we use some of the other Medicaid rules like around annuities, maybe we want to buy a Medicaid qualified annuity that'll pay income for the same period of time as the ineligibility period. So maybe a 10-month annuity that would pay income. So we make the gift, buy the annuity at the same time, and then file a Medicaid application. Just disclose all this to the county assistance office, hoping to get back a determination that yes, you're ineligible for this 10 months, but your annuity is approved. So then we'll just use that income from the annuity to pay for pay for care for the next 10 months.
Before you become eligible.
Yeah, now we preserve the gift. So doing something like that with a single individual, you can protect maybe about half of the assets in a crisis Medicaid situation. So then that raises the other question, well, can we use that 5-year look-back period proactively? And that's where we get back to the trust. So if we have a single individual, maybe we want to think about, if they put their house and some of their non-qualified savings into an asset protection plan, an asset protection trust, then after 5 years, there's no penalty, right? So then those assets would be protected going forward.
So the trust planning has to take place 5 years before the need, basically.
Ideally, yes.
Right. And how I would explain it to clients, but I think that you added something to it. I would normally explain that, say someone goes into a nursing home today, they have to cover like a 5-year period, so they can gift enough assets outside of the trust and keep enough in to pay for it. So to pay for those 5 years. So then, 5 years and 3 months goes by, nursing home looks back, and they used to have $2 million, and they gifted a lot of that out. They kept enough to pay the 5 years, and there's no problems. But you're saying you can even do more than that with the Medicaid annuity and making them eligible even quicker. Is that what I'm hearing?
Yeah, so I guess if a person has done no planning,
Right.
if they got to that point where they're in a nursing home now, we might be able to protect about half, up to a certain limit. If they have $300,000, might be able to protect around half of that.
Okay.
With a crisis Medicaid plan.
Got it.
So then you think about, well, how much would you need to pay for 5 years of care if they get $2,000 in Social Security a month and it's $12,000?
You need 10.
$10,000 a month times 60, 5 years, right? So that'd be $600,000.
Right.
So if they have $900,000, maybe we've got some to play with.
So you
we've
take
got-
the 300,000 out and you keep the 600 to pay. Is that? What
Yeah,
I'm
that might be a
hearing?
good approach.
Okay.
Yeah.
Because I think a lot of people think once you go into the nursing home, that's it. You can't do anything. You can't do any more planning, and that's not the case.
That's not the case.
Right.
I wanted to ask one more question on this topic, and then one question is kind of a closing out piece. The question on this topic is, so a client's working with you, they get all these strategies in place and say that the timing was perfect for the 5-year look back, they're on track to qualify for Medicaid. When they get to that point, what does that look like in reality? What's the process for applying for Medicaid? Are they being referred out to work with someone else that can help them apply for that? Are they doing that on their own, or are you and your team helping them? What does that process look like?
Yeah, so it starts with being in a facility that is a Medicaid certified facility,
Okay.
and most of the skilled nursing facilities are in this area. So you just have to make sure that you're in that facility. Once you're in that facility, whether you're private pay or on Medicaid, you get treated the same. So if you start out being private pay and you qualify for Medicaid, you're going to stay in the same bed. So then it's a matter of, if they're already qualified financially, the nursing home will often help them with the Medicaid application.
Mm-hmm.
If they require some additional spend down or something like that, that's usually when we'll get a call and
Sure.
and we'll help them, put the last pieces in place so that they can qualify in a way that's the most financially beneficial to them or their spouse or their
Sure.
kids.
Okay.
Do you ever get calls from nursing homes to help, or do you find out that you tend to almost like compete with them because they'd rather have self-pay than Medicaid pay?
We sometimes get those calls. Yeah, so somebody might recognize, well, here's somebody that could really benefit from this type of plan, and I want to refer them to somebody that can help them with it, because at the nursing home, yeah, they can help them with the application,
Right.
but they certainly couldn't help them with the type of planning that we do.
And you, when you were answering my original question, you brought up, I think this is a misconception, so I wouldn't mind hearing from you. Is there a difference in the quality of stay for someone on Medicaid versus someone that's self-insured versus someone that has a long-term care policy?
Not within the same facility, so they can't discriminate against somebody because they're qualified for Medicaid. Whether you might get a different, facility. If you're totally private paying, I suppose you have your choice of any facility
Sure.
that you want. So if you're going to need to qualify for Medicaid potentially, that would limit your choices somewhat.
Okay, gotcha.
Are the facilities pretty similar, or is there a big difference in quality between Medicaid, like specific, compared to something it's not?
I think there are a lot of good facilities that I get good feedback from my clients
Okay.
about that are also Medicaid certified facilities
Got
too.
it. Okay.
And most often, it sounds like you're seeing people maybe go into the home, probably still doing some planning, so they would not be on Medicaid at that point, but maybe some point in time during their stay, then they qualify for Medicaid. Was I understanding that correctly?
Right.
Okay,
Yeah,
gotcha.
because they actually look at what are your assets on date of admission to determine things like how much can the community spouse keep.
Gotcha. Okay.
I was curious about one thing. Go ahead, Ryan, in case if...
No,
I-
you asked your question.
So what I was curious about, a lot of our clients have a fair amount of qualified money, IRA, 401k, and is there any way that can be protected?
Like in a nursing home situation?
Nursing
something
home,
like
or
that?
just general asset liability, is it how protected is that money?
Yeah, so you have certain protections by law from things like lawsuits and that sort of thing.
Okay.
Probably the most famous example is O.J. Simpson. When he had this big civil judgment against him, he had to sell his house and his Heisman Trophy, but his NFL retirement plan was protected, so he lived well. So there are certain protections that way. Again, if you're like a community spouse, it's protected in the sense of Medicaid nursing home spend down.
Okay.
And then often I think of it in terms of people who are inheriting these accounts. Apart from the clients that might have to qualify for Medicaid, but anybody that has money in a traditional IRA or 401k, if you're going to be leaving that to your kids, what happens when they inherit it? And so with something like a see-through trust we can set up for their kids, they can still get the full amount of time that they're allowed to take it out, and get all the tax deferral and growth that they're entitled to. Maybe it's 10 years, might be longer depending on their situation.
Right.
But so we try to preserve that, but let's see if we can set it up in maybe a trust that the kids can benefit from, so that if they get divorced, if they get sued, something like that, what we're leaving them from our other assets, our non-qualified assets, and our qualified assets maybe will go into a trust for them and be protected.
So if someone has an IRA, like they inherit an IRA, the money comes out because they have to take it out, their required minimum distributions, let's just say over a 10-year period. So that money goes into a trust.
Right.
I guess it's an irrevocable trust. Is that correct?
It would be a testamentary trust.
Testamentary,
So
okay.
it goes into effect after I'm gone,
Right.
and it's maybe set up for my kids.
And then that's protected, so they can get income from it, but it's protected.
Yeah, and they would have access to it, a lot more access than you would be able to set up yourself,
yourself.
with like an irrevocable trust.
Got it.
But, the kids would have much more ready access to take money out, but we can set it up in a certain way so that if they got divorced, whatever they chose to leave in their trust would not have gotten commingled into their marital assets and have to be subject to equitable distribution.
Is there any way that, say I inherit an IRA and I want to change the beneficiary, so it doesn't go into a trust, it just comes directly to me, is that possible to kind of undo all that planning?
Oh, if we've set up a trust like that for
Yeah.
them? Yeah, so we would generally set it up so that, if we're talking about responsible people, that, not somebody that's a spendthrift or, special needs or anything like that, but just, a regular responsible adult, I would typically set it up so that they could take out as much as they want. If they want to not have the trust anymore, take everything out of it. But hopefully they've gotten educated and they'll understand that if they leave it in, what's the advantage of having it protected in there?
There is no doubt that this is complex and there's a lot here. I know, so for our clients, as these conversations come up in meetings, we can obviously introduce you to Andy and his team at the appropriate time. In the blog post version of this episode, I'll have Andy's, a link to his website, his contact information, etc. But the final question that I have is, if any of our listeners are interested in learning more about what you do, where do they go? How do they find out more?
Yeah, I appreciate the question.
Yeah.
So the website is a good resource. You could just search for Sykes Elder Law or go to the link that you'll provide. Mm-hmm. And then also on our website we'll list upcoming seminars. So that's a good way to get introduced too, is to look for our upcoming seminars and sign up for one of those and come to one either in Pittsburgh or Philadelphia and learn more. Spend an hour learning more about what we do.
Perfect. And one last question, because I know at the beginning of the episode you mentioned an office in Philadelphia and an office in Pittsburgh. So are you a Phillies sports fan or are you a Steelers sports fan?
It's a very important question.
I'm both. I'm a Steelers fan and an Eagles fan.
Oddly enough, I am too. I lived in Philadelphia for a little while. I like a lot of players on their team, so I'm both too. But
Wonderful.
Andy, we appreciate you joining us today. Thank you very much.
Okay, thanks so much for having me.
This episode's content is for informational purposes only. Opinions expressed herein are solely those of Wyze Wealth Advisors, unless otherwise specifically cited. Material presented is believed to be from reliable sources, and no representations are made by our firm as to other parties' informational accuracy or completeness. All information or ideas provided should be discussed in detail with an advisor, accountant, or legal counsel prior to implementation.